Yeah, they all gave me an excellent education. So when I was at the Royal Military College, my degree was in history, which I think many lawyers will say that what they study earlier on can be of help. So political scientists can learn a lot to apply in a legal context. Historians can. Law as a discipline which should encourage sort of a broad-based background. When I went to, I was in the military, and then I went to, I was an infantry officer. I got out and went back to law school, and what my bachelor's, my undergraduate law degree, taught me was, I think, the fundamental that a lawyer should think of two sides of an argument in crafting their responses, and also they provided a desire to have a lifelong education, to self-study. I went back for my master's at the same university, Queen's, and I actually studied Canadian constitutional law. So it didn't have a lot of relevance to that part of my career. It did to my military discipline part of my career. I went to Harvard. I went to Harvard as a visiting fellow, and I went in 2002, and there I studied the role of human rights in armed conflict. So it directly was both relying on what I had experienced as a legal advisor to the state, but it also, because of the changing nature of conflict, it allowed me to think of how human rights law should be considered more and more. But it all added up to help me in my legal career. I think one of the main challenges for humanitarian law is struggling to deal with the conflict against non-state actors. It's a body of law which, particularly from a treaty perspective, has been focused on interstate conflict. And this has been the struggle since 2001 on, as the international community has tried to reconcile how humanitarian law applies in conflict against non-state actors. One of those challenges is there is not a lot of interest in developing new treaty law. You actually would have expected, if you go back through the history of humanitarian law, about every 25 years there was a new treaty dealing with humanitarian law. And that occurred right up until just before the turn of the century. And at this stage, it's such an unsettled time that both states and humanitarian law advocates are leery of trying to develop new law. And the focus has been on enforcing the law that we already have and working to get a better understanding of customary law. And a lot of people have that perception. And one of the challenges is that they have far more interaction than many people really consider. There are a number of writers who consider humanitarian law a form of human rights law. And I think it's very safe to say that laws like, for instance, Geneva Convention 4 for occupied territory is seen as, and has been described as, a mini constitution, a sort of human rights-based law. The additional protocols to the Geneva Conventions incorporate human rights law. And so the reality is that, as was said by the International Court of Justice, in some cases humanitarian law only will apply, in other cases only human rights law will apply, but there are also situations where both bodies of law apply. And the challenge now, I think, for the international law community is to really give some serious consideration of what happens when the two bodies of law apply at the same time, and which option the states are going to use in terms of the body of law they're going to apply in an armed conflict. Yeah. The best advice I can give is international law as a career truly requires an open-mindedness to the law and other people's views. And there's a tendency sometimes to get bound into human rights law or bound into humanitarian law And as I mentioned during the lecture, the world is too messy for narrow options in trying to deal with the problems that human beings create. And so it is being open to, the other bodies of law and all the bodies of law that can apply during peace and armed conflict. Thank you very much.